Zealand who will be grateful to see that that change has not been made. The Firearms Safety Authority also will remain in police. That was promised to be taken out of police. When we looked at the costs associated with that early on, we asked those questions and did not get answers, but it is now clear that the cost would be over $500 million to take the Firearms Safety Authority out of police. Also, what it does is it stops potentially that real-time access of intelligence. When someone has had their weapons removed, that is up front when police officers are attending in a call-out. That information is vital for the safety of our frontline and for the safety of our communities. So we are heartened to see that the Firearms Safety Authority is staying where it is. The Firearms Registry also remains intact. The Firearms Registry commemorated a big goal just recently in November, with over 50% of those people who are licensed now using the registry for their weapons to be licensed through that. That is a huge testimony to the fact that people do not have a concern with trust and confidence, and that they are making sure that they use Te Tari Pūriki, the Firearms Safety Authority, and making sure that licences are now included in that registry. That is an intelligence map for our police to be able to use to know where the legal firearms are, and when we know when the legal firearms are, that makes it a lot easier to trace where those ones who have been diverted are going. So we still have some concerns with this bill, Madam Speaker, and I think it's important we point those out. The provision in this bill that no police will have involvement in the Firearms Safety Authority, or blue shirts as referred to by Nicole McKee in her press release. We've had no real reason as why we would not draw upon the institutional knowledge of New Zealand Police and firearms when making these changes to our Act. They are the ones that have the most experience and the most insights, and it does seem somewhat of an ideological move to remove police from having involvement. I'd be really interested to know what the Minister of Police has to say about police not having involvement in the FSA under its new restructured form. The second one we would like to know about is the funding. There's no clear indication of who's paying for this restructure, potentially up to 50 or 60 million for a full restructure of the Firearms Registry, but unclear whether that's coming out of a police budget and impacting on frontline services, or whether it's a Ministry of Justice budget. It seems like it'll be a separate budget bid, so we would be very interested to know who's paying. And finally, we want to know at the implementation dates that these changes will take time. We want to make sure they're embedded properly. For this reason, we want to make sure these changes are made appropriately. We'll be supporting this bill to Select Committee on the clear reason that we want to make New Zealand safer, and that we're heartened by the fact that those initial threats made by Nicole McKee of military-style semi-automatic weapons, Firearms Safety Authority out of police, and changing the Firearms Registry, all of those do not change. We think that this is a win for public safety in New Zealand, and it shows that we, even though we have a firearms lobbyist as the Minister, she's been unsuccessful in achieving her goals.
Madam Speaker.
Scott Willis.
Thank you, Madam Speaker. This bill, the Arms Bill, which repeals and replaces the Arms Act 1983, has the laudable goals of aiming to provide for greater protection for the public, simplifying regulatory requirements and improving compliance. So those are all really laudable goals, and the bill, as it stands, could well achieve some of these things. On public safety, as we've heard, there are good changes, such as recognising that multiple people within the system share responsibility for safety. Regulating blank firing guns, which we know have the potential to be transformed into live conventional firearms. Restricting high-capacity pistol magazines to endorsed licence holders. Requiring firearm businesses to notify the police of all surrendered firearms that will enable checks on those firearms to see if they have been involved in criminal activity or stolen, and requiring the regulatory approval for commercial ammunition sales. Now, these are all really good things, and there's a range of new offences as well which will address real risk and help future-proof things, like new offences like failing to notify the loss or theft of a firearms licence, the unsafe storage of firearms, possession of firearms without a serial number, possession of files that would enable 3D printing, as we heard, or intentional diversion. And as a parent, I really do support the change allowing licence holders to have secure storage facilities at any location approved by the regulator, such as in My Gun Safe rather than in a flat somewhere in Wellington that may not be as secure and may not be desired by the landlord. This certainly will reduce risk, and it is part of the really positive changes that we see in this bill. And I'm particularly pleased that the Associate Minister did not succeed in allowing greater access to military-style semi-automatic firearms. That's a rare moment of spine shown by National to stand up for something. But we know the Minister wanted to and still wants to give public access to military-style semi-automatic firearms, and we're concerned that some changes have been made more from spite than from any rational concern for public safety. So while this bill, as it stands today, does offer a number of improvements, it makes one big change that we believe will create more risk and reduce oversight and transparency. And for this reason, we will not be supporting this bill in its current form. Removing the regulator from the police seems more like a petty, vindictive act based on some vibes from some small group of firearms owners than any responsible act. The police have a unique and valuable perspective because they're on the front line of gun violence. They're often exposed to gun violence and they're at the greatest risk of gun violence. That free-flowing information flow is valuable in reducing risk, but their expertise is not included in the regulator, and that is extremely problematic. Instead of repairing the relationship and rebuilding trust between firearms owners, businesses and the government, the Minister has stripped the police of responsibility as some kind of weird punishment. The police should be involved in the regulator and in addressing violent crime rather than being tasked with responding to mental health issues. So we understand that this bill will proceed without our support and will move on to Select Committee. However, I would encourage the public listening and my Labor colleagues here to seek the retention of the regulator within the police, reporting to the Police Commissioner, because we can't allow some petty punishment for some imagined slight to reduce public safety by removing police oversight. The police who deal with violent crime and gun violence, removing the police just increases the risk to the public, and for this reason we oppose the bill in its current form. Thank you.
I call Carl Bates.
Thank you, Madam Speaker. Madam Speaker, this Act is designed to ensure that we promote the safe possession and use of arms. And there's a couple of things within the Act, or within the bill rather, that I thought I would highlight as part of that objective. The first is the clarification of the 60 offences down into 8 offences. I think that really ensures that we're clear that there are offences for doing things wrong, but we make them easy to understand. And secondly, the independence of the Firearms Licensing Review Committee. So therefore I commend it to the House.
Madam Speaker.
I call the Honourable Dr David Wilson.
I rise on behalf
of... not the Honourable, just the Dr David Wilson. Thank you.
I'll respond to both.
Okay.
I rise on behalf of New Zealand First in this first reading of the Arms Bill. We'd like to commend the Honourable Nicole McKee for her work on this bill. Relevant, practical, balanced. This bill is not about ensuring New Zealand's firearms laws are fit for purpose in the 21st century. Should I say that it is about that? The Arms Act 1983 has served us for decades, but recent events and reviews have shown gaps in licensing, compliance and enforcement. For example, responding to the emerging technology in firearms such as 3D printing. The Arms Bill strengthens oversight of firearms ownership, dealers and clubs while ensuring legitimate users can continue their activities under clear and fair rules. New Zealand First has always stood for balance, protecting public safety while respecting the rights of responsible firearms owners. Our party policies have consistently emphasised the need for strong licensing, secure storage and tough penalties for criminals, while ensuring that hunters, farmers and sporting shooters are not unfairly penalised. We believe in practical, enforceable laws that target misuse, not tradition. We support this bill because it delivers exactly that balance, Madam Speaker. It strengthens police powers to deal with unlawful possession and trafficking, ensures dealers and clubs meet modern standards, and introduces tougher penalties for those who misuse firearms. At the same time, it provides certainty for responsible owners, recognising their role in rural life, food production and sport. For New Zealand First, this bill is about fairness, ensuring criminals face consequences while law-abiding citizens retain their rights. Madam Speaker, we commend this bill to the House. Thank you.
Madam Speaker.
I call Orini Kaipara. Thank you.
Tēnā koe. Thank you, Madam Speaker. Before setting out Te Pāti Māori's position on this bill, I want to acknowledge the wider context we're debating it. Across Aotearoa, many communities are confronting rising violence, deepening inequality and ongoing pressures that disproportionately affect those with the fewest resources. Those communities, as we very well know, are tangata whenua. Firearms legislation sits at the crossroads of public safety, political influence and community wellbeing. How this House chooses to regulate firearms is not just a technical exercise. It reveals whose safety is valued, whose voices are centred and whose interests are given priority. It is in that context that I rise on behalf of Te Pāti Māori to oppose the Arms Bill 2025. Our position is clear. This bill shifts power away from the community safety and toward political interests, including powerful firearm lobby interests, while failing to address the real drivers of harm in our communities. This bill includes over 50 separate policy changes. It rewrites more than 60 existing offences and creates 8 new offences. It loosens rules for firearms users, pest controllers, collectors and dealers, and it establishes an entirely new firearms regulator deliberately distanced from sworn police oversight. And we must be honest about where this direction is coming from. This government's decisions appear aligned with the interests of lobby groups rather than with the people most affected by gun violence. The move to hand all regulatory powers to a new independent regulator is not necessarily about improving safety, Madam Speaker. It risks politicising gun control and weakening safeguards that were strengthened after the 2019 Christchurch terrorist attacks. Recent data suggests that gun crime in Tāmaki Makaurau is rising, and that the majority of these offences involve illegally owned firearms, not licence holders. This trend shows that loosening regulation doesn't necessarily help the people, like our hunters, who use firearms responsibly, but rather may benefit those who obtain guns illegally or misuse them. From a Māori worldview, whānau who use firearms responsibly for hunting, pest control, or mahi on their whenua contribute to the oranga or the well-being of their whānau and whenua. Our concern is not with them, our concern is with protecting life, whakapapa and mana, which demand strong and culturally informed regulation. If this government were truly serious about reducing gun harm, it would invest in whānau support, violence prevention, housing security, mental health services, kaupapa Māori responses, and action against illegal firearms, not deliver a bill shaped by lobbyists with weakened oversight that sidelines the voices of people living with the consequences of gun violence. Therefore, Te Pāti Māori cannot support a bill that, under the guise of reform, shifts power away from community safety, risks public safety, and ignores the real issues facing our people, not just Māori, but all New Zealanders. The responsibility of this House and of this government is to protect our communities, our whakapapa, and our mokopuna, not to appease political pressure groups.
Madam Speaker, let's clarify two things for the previous speaker. Purpose of the Act: promote the safe possession and use of arms, and secondly, impose controls to prevent the possession and use of arms for criminal activity. It's a good thing, Madam Speaker. It's a really good thing for New Zealand, and therefore I commend it to the House. I get a refund.
Madam Speaker, for many people in Aotearoa today, this is actually a moment of relief. And the strange thing is that it's a moment of relief not because of what's in the bill, but because of what's not in the bill. For so many people, they've been concerned that the shift we'd be discussing today would be a shift to change our position on semi-automatic weapons. And that is not the case. That has been a failed attempt today because of the work on this side of the House, but also because of the work of many people in the Muslim community and many people in the community who've been lobbying against that. So I did want to just acknowledge Philippa Yazbek from Gun Control and the important work that she's done, but also the Federation of Islamic Association chairperson Abdul Razak, who said one of the key legacies of the 51 Shahada was to make New Zealand safe, particularly from the menace of the semi-automatic killing machines. So this is an important moment to mark what grassroots campaigners, what our ethnic communities can do when they have their voices heard by this House, and I think it's extremely powerful. We will be supporting the bill through to Select Committee, but as the Honourable Ginny Anderson has said, there are concerns that we have and things that we will be raising. The bill is a significant one, 232 pages to go through, and I'm looking forward to really robust submissions from those in the community about the detail of the bill. I do want to acknowledge the officials who produced this, this great document called Arms Bill Explanation of Proposals. It has an excellent spreadsheet that goes change by change through what the law is now and what the changes will be. A huge aid in terms of making those submissions. And I wanted just to speak to some other choices that have been made in the body of the bill, which I'll certainly be questioning at Select Committee stage. So the first one is in relation to the health-related licence suspension. So right now, if people are deemed not to be in a sufficient state to hold a licence, those licences can be suspended for 3 months. And if the licence is not reinstated in that 3-month period, then it expires. The person cannot apply for another licence for a 10-year period. Now, there's a change in this bill that extends that to a 12-month suspension. On the one hand, it feels like that would mean a potentially safer community because those licences can be suspended for longer. However, it also gives the person the opportunity to remediate whatever the issue is, which then avoids the 10-year problem. So it's a choice that's been made that strikes a particular balance. The question is that balance the correct one? Another interesting one is around the definition of penalties and what constitutes premises or not. So the current law assumes that you must keep the licensed firearm in a secure place within your premises where you normally reside. Now, for many people, that's not going to be the place where they normally reside. And the example used in the document provided by officials was students, for example, who may be flatting elsewhere, but may need to keep their firearm in a location that's separate from where they live. So some extremely sensible changes made. including changes around the printing of parts of what could be used as a firearm. So acknowledging that technology's developed in a way that means we now need to accommodate for that. There is Section 7 Bill of Rights Act advice to the committee on this as well that says that the bill is compliant with the Bill of Rights Act. However, there are a few matters to interrogate for the committee as we go through select committee stage. One is around freedom to relay or not to relay information, and the requirement that people have to disclose their personal details to the police when asked. The current assessment is that that is a fair limitation on rights, but I do think that that is something that the committee will need to interrogate, and I certainly hope we receive submissions on that, Madam Speaker. So for the time being, I do commend this bill to the House, but again urge submitters to come having read the spreadsheet and just give us our assessment on whether they believe that the ground struck between some of these difficult choices is the correct one. Thank you.
Rima Nakle.
Thank you, Madam Speaker. My favourite proposed change of the arms bill is that if someone chooses to be a member of a gang, then they will be automatically disqualified from holding a firearms licence. I commend this bill to the House.
Helen White.
Thank you. First of all, I want to reiterate what Venushi Walters just said about the great deal of relief that people will feel that we are no longer looking at semi-automatic firearms coming back into our communities. That's an incredibly important thing. I was very aware of the stress that that was causing and the way that people felt about it on the ground, that they felt that there had been, there was not sensitivity around what happened in this country. And I, like many other people, will remember exactly where I was on that day as this terrible, terrible event unfolded in our country. But I wanted also to talk about my portfolio, because I have the sexual and family violence portfolio and the implications for people of this law. I am very pleased to see this going forward in the form it is to the Select Committee. But I too am concerned about the police not being as involved as they were, and I don't really understand why that is. And I would urge people who are submitting, who have had experiences, particularly experiences of domestic violence or fear of domestic violence or family harm, to come forward and to tell those stories, and for the Select Committee to be sensitive about how they get to tell those stories, because they're often very fearful of doing that. And I wanted to talk about an incident the other day that happened when we were in Scrutiny Week, and we had the Justice Committee moved to the part of scrutiny which was about the Sexual and Family Violence Centre. And as we spoke about a particularly serious and very worrying new development, which is a lot of promotion of rough sex on the internet, and people being involved in situations where they were simply confused about whether they had a right to be upset about what had happened to them, or to claim that was abusive behaviour, because things have just moved so far. And as we talked about that subject, a police officer who I'd actually given a pretty hard time to about the call-out changes from police, and I thought that she probably didn't necessarily like my questioning, but she came to the front of the room and she said it made her hackles rise, because she was seeing the very behaviour that I was discussing on the front line over and over again, and we needed to do something about it. And I thought about the value of her role as a police officer in that situation. Our police in are absolutely in the front line, and people like the woman that came into that situation, they have a very grounded, realistic view of complicated issues. They get to see things I wish I never saw, and they do carry that experience and that responsibility. And if you look at this bill and you think about that experience and responsibility in the context of people who may harm their family members with guns, may be subject to mental distress, may be angry, it's really important that our police who see that participate in this process. So I have a strong belief that the police should be involved in this process, and I would really like it looked at the Select Committee as an issue. And I take my friend Venushi Walters' point that the 12-month suspension probably has arguments for and against it, and I'd really like that looked at that time and with an open mind, because these bills, they make a difference to whether people live or die, and it's a really responsible thing to do, to listen to our submitters and think through these things with an open mind. I commend this bill to the House.
I call Mike Busherick.
Thank you, Madam Speaker. This is a good bill because it clarifies the law and closes some loopholes. And as my good friend Rima Narkley said, it also makes gang membership an automatic disqualifying factor for holding a firearms licence, and that's a good thing. I commend the bill to the House.
The question is that the motion be agreed to. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it.
Arms Bill, first reading.
The question is that the Arms Bill be considered by the Justice Committee. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it. Members, I call on order of the day number 2.
Speaker.
Honourable Chris Bishop.
I present a legislative statement on the Fast Track Approvals Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
I move that the Fast Track Approvals Amendment Bill be now read a second time. Madam Speaker, it's a privilege to be back before the House to present the bill for the second reading. When the bill was introduced on the 3rd of November, I said and repeat again that the bill has 2 complementary priorities. The first is promoting competition in the grocery retail sector, advancing a core part of the government's Going for Growth agenda, which will have flow-on effects for productivity and living standards. The second is to make changes to improve the fast track regime's workability and efficiency. Fast track is working pretty well, actually, and we've had a number of projects that have already been consented and received approval. In fact, some of those projects are underway, like the Ports of Auckland expansion or extension and the new ferry or the new cruise ship terminal. Maitahi, which I'm visiting tomorrow, which is a housing development down in Nelson. Fast Track's working pretty well, but all regimes, particularly ones as complicated as Fast Track, benefit from fine tuning. So over the course of this year, there has been feedback sought from targeted engagement with applicants, with agencies, and the panel conveners themselves, actually, who are doing a good job processing all these applications to try and find operational and procedural efficiencies. So the bill includes a range of amendments to speed up the application process, reduce timeframes in key areas, improve flexibility, and to clarify a range of operational matters. I do want to acknowledge the Environment Select Committee, who have had a short but thorough look at the Approvals Amendment Bill, hearing submissions and considering the bills. There were many submissions made during that short process. There were quite a few themes that came through from submissions, including if proposed changes would allow for consideration of environmental issues, how they would accommodate treaty and other arrangements with Maori, concerns about government input in the decision-making process, representation for local communities, the GPS process, the government policy statement process, and timeframes, including for panel decisions. Some submissions concern changes to the current Clause 42 of the bill, under which parts of an application
can be withdrawn after an application has been lodged. Some submitters expressed concerns this change could lead to project scope being expanded mid-process. The legislative process has led to a clarification. Modifications cannot be made that result in the application expanding the scope of the project beyond its original description in the referral application or as it was listed in Schedule 2 of the Fast Track Approvals Act 2024. Ministerial direction in this area is intended as a backstop in the event expert panels are uncertain if a project, if modified, will continue to have significant regional or national benefits. This makes it clear that expert panels can continue processing applications as modified without seeking a direction from the Minister. Several submissions reference previous mining cases or applications under the RMA or concerns regarding long-term environmental risks or considerations. The bill does not seek to change the expert panel's role in determining whether identified adverse impacts are out of proportion to the project's benefits and to impose appropriate conditions on approvals. The bill introduces a new requirement for applicants to provide information on effects in their referral application, which will help inform ministerial referral decisions. The Minister for Infrastructure has the discretion to decline a referral application if it would have significant adverse environmental effects, and I note that I have declined some referral applications already through the fast track process. Changes will be made to several key timeframes for decisions in the fast track process. Decision timeframes to date have varied due to the complexity of individual applications. However, in line with the Act's requirement for efficient processes, clear statutory timeframes give applicants and investors greater certainty about process and cost. Having heard submissions, it is sensible to increase the maximum time limit for an expert panel's decision from 60 working days to 90 working days, which can still be extended with agreement from the applicant. The timeframe for parties to provide comments on referral applications is reduced from 20 to 15 working days. Regional councils must respond to requests for information about existing resource consents within 10 working days. Previously, there was no previous statutory timeframe. The intention is to achieve a balance between the requirement for timely information and the need to maintain accuracy and avoid placing unreasonable burdens on councils. The panel convener and others provided informative submissions on how reducing the time taken to establish panels may not be workable in practice, and the government has established it as preferable to maintain the status quo and have no statutory timeframe for panel appointments. Efficiencies will be realised when certain steps in the substantive process, such as completeness checks and competing application checks, happen concurrently. Applicants invest significant time and resources, and it doesn't make sense that they should be penalised if application circumstances change and they want to pause their application. The maximum time that an applicant can request the suspension of their application is proposed to be increased from 50 to 100 working days. This is to allow applicants more time to provide information to address concerns raised by parties invited to comment on applications. In relation to government policy statements, these were proposed so projects' regional or national benefits were more easily related to government policies and priorities for development or growth across a range of sectors. They will be issued by the Minister for Infrastructure. GPS set out the government's policies on the regional or national benefits of certain types of infrastructure or development projects. The Minister for Infrastructure will consider any relevant GPSs during the referral process. The expert panels will do the same when deciding whether to approve a project or set conditions, or approve a project and set conditions, or decline them. Some submitters were supportive of the GPS mechanism as drafted and thought it would provide greater clarity and certainty for nationally significant issues. Others considered the grocery retail GPS a good template for future development in other areas, such as urban development and to enable infrastructure. Developing GPSs will not happen in a vacuum. Section 10A of the amendments outlines how they will be issued and who may be consulted. The bill amends a number of project descriptions and updates the respective project descriptions, locations and authorised persons, including for the Stella Passage project. There are also transitional provisions to ensure fairness and clarity for applications in progress. Any changes that do not require system or IT updates will take effect immediately. Some changes that require system updates will take effect on 31st of March 2026. The bill's legislative process has delivered a range of sensible outcomes that, if adopted by the House, will balance the need to improve Fast Track's efficiency and workability while still preserving the ability to facilitate regionally and nationally significant infrastructure and development projects and deliver robust decisions. As I say, Fast Track is working well. We have listened to some of the feedback that's come through the Select Committee process, who I think did a good job hearing the submissions. Members will note that the government has lodged an amendment paper yesterday, actually, which is available for everybody to see. So as we get into the Committee of the Whole, we can work our way through that, which picks up on some of the submissions. My understanding is the Select Committee did not do an RT version, so essentially the Committee of the Whole House stage is the ability for the House to make amendments to the Fast Track Approvals Amendment Bill, and I'm looking forward to considering that in the Committee of the Whole. As I say, there's twin objectives to the bill. One is around grocery sector competition, which I think is broadly supported across the Parliament. I think I'm right in saying that. And the second is some efficiency and workability improvements to the original fast track regime. Having decided to do the grocery sector competition, the government thought it was worthwhile making these sensible finesses and tweaks to the Approvals Act. As I say, it's working well. Everything can be better, and that's the aim of this bill. Thank you.
The question is that the motion be agreed to. I call Honourable Rachel Brooker.
Thank you, Madam Speaker. And I'm interested in one of those last remarks from the Minister, that he acknowledges that there is general support from around the House for increased grocery competition. And if he will remove his Facebook post that he made immediately after the first reading of this bill, saying that Labor didn't support supermarket competition, that Labor had voted against it. And then noting his further comments that he made, whereby he said, oh yes, and I'm paraphrasing somewhat, Labor has some fair points about the fact of the supermarket competition being entwined with a whole lot of other issues, but they can vote on that clause by clause when we go through the committee stage of the bill. So I hope the Minister holds to that. My main point, of course, is this bill is not about supermarket competition. If it was about supermarket competition, we would have not been rushing this through the Select Committee in the way that we did, and there may be general agreement about all of the changes, but Madam Speaker, there is not, because what this bill is about is enabling ministers to delve down into the substantive decision making on these decisions. These are decisions that already have normal environmental protections degraded, Madam Speaker. And that is the problem with the Fast Track Act, the Principal Act, and what this bill does is make it even worse. It's not about speed, it's not about a one-stop shop, it's about ministers making decisions. And we saw when the Fast Track Bill, which is now the Principal Act, when that first came out some time ago, there was talk of Muldoonism. And the Minister says he doesn't like Muldoonism, and that in fact he has Fitzgerald and Muldoon on his wall. But and we had protests down Queen Street, and Glenn Bennett was at that protest, and it was all the way down Queen Street because people were particularly worried about ministers making decisions on important issues that need to be considered with evidence in front of a robust decision-making process. That seems like something that the Attorney General would want. And the change was made. So the ministers in the Fast Track Act do not have that ability to make the decisions. But what this bill does is introduce a new mechanism, a government policy statement. A government policy statement that is made on the whim of the minister. There are no criteria. There's a little amendment that's just been made that, they can consult other people if they want to. Whoop-de-doo, Madam Speaker. That is not a robust process, that is not criteria, and it is different from other pieces of legislation, apart from, of course, the recent amendments to the Crown Minerals Act, whereby there are criteria for anything that is called a government policy statement or words to that effect. So I have suggested an amendment, which I hope the Minister will consider, that provides some criteria for that government policy statement. Now, if the Minister was committed to this bill being about supermarket competition, then the provisions in the bill could specifically refer to supermarket competition, that the government policy statement is to be about grocery competition, but it does not do that. No, it is much wider, and that is the concern that we have and that many submitters, many very thoughtful submitters, including the Parliamentary Commissioner for the Environment, amongst others, about how this, and even the New Zealand Institute, about how this is ministerial overreach, and it is very serious. So that is one issue. Another issue, Madam Speaker, is the process through which this bill has gone through to this point. Normally, if we're reporting back from a select committee that has a report back period under 4 months, there would have been a debate in this chamber from members across the chamber about that shortened time frame. This did not happen for this bill. Instead, the chairperson decided to have a very short submission period, and then the majority of that select committee agreed to report back early. That is not a good process. So it meant, and the select committee did work very hard, and the officials all worked very hard as well, and I of course commend their dedication to doing their job and being good public servants. But it did mean that we did not have a long time for submissions, and of course we haven't got an RT, a revision tracked version, with the select committee report back. The Minister just referred to the amendments coming in yesterday. When I was looking for his amendments yesterday, I could not find them. I note that they have been tabled now for at least an hour or so, and I have been going through those diligently and will refer to them at some length in the committee stage. But that is not a good way of making laws. And it also has meant that a whole lot of submitters brought to us good points. Now, the Minister has described this bill as supermarkets and rats and mice. There are some rats and mice in this bill, and being from Dunedin, I'm careful when I talk about supermarkets and rats. that is Speaker. I note the Minister for Food Safety is in the House. And it's just outside my electorate on the other side of the road. And thank you for the offer of cats. So, Madam Speaker, though, whilst there are some small issues, there are also these bigger issues that I've been talking about. And it would have been, if you're doing a tidy up of a bill that you've only passed a year or so ago, and I'm all for reviewing bills and all for having good regulatory systems, then we could have had a good, robust process. So, for instance, Queenstown has an awful lot of listed projects that relate to Queenstown, and Queenstown's population is not giant, and the council has limited ratepayers and limited resource. And Queenstown is a beautiful place, and it is growing, and the council has been trying to plan for its infrastructure and where that additional housing growth should go for a long time. And it's very important that there are more houses in Queenstown, Madam Speaker. Nobody is debating that point. But the councils from both Queenstown and Central Otago District Council, so that includes Cromwell, where there's a lot of commuters living who go in and work in Queenstown, they came to the Select Committee and said, look, Queenstown has the most unaffordable housing in the country. Queenstown has had special legislation about housing before. Nick Smith did a special housing accords piece of legislation, and as a result, there was a requirement for affordable housing. Now, they made the submission to the Select Committee, look, we're the ones with the most unaffordable housing in the country. We are the ones with the most per capita fast-track applications happening here. Surely there is an argument for a specific requirement for those developers who will be getting huge uplift from rurally zoned land that will now be developed with housing. Surely there is an argument for a special requirement for, say, 5% affordable housing in those projects. And that seems to me like a very legitimate argument. I, of course, don't want to make a decision on it because we haven't heard any analysis from officials about that, because, of course, there was no time to do so. And that is a missed opportunity, Madam Speaker. And that is because this government continues to want to just rush things through and not have some good thought to what is actually happening. And we're going to have many questions about the amendment paper that the Minister has put up about what the consequences of the changes are, because again, we have not had that analysis. Now, Madam Speaker, there are many other changes in this bill that are not to do with supermarkets or rats and mice. And some of them are to do with limiting participation of other groups, and there are some changes in the amendments that we'll talk to in the committee stage. But particularly, we heard from iwi groups that the timeframes in the fast track at the moment are already near impossible. So any further reductions of those timeframes will mean that their participation is mere rubber stamping. They cannot do substantive, thoughtful contributions, and that is what we want, because we are concerned here about our environment and protecting it. Thank you, Madam Speaker.
Thank you, Madam Speaker. Are you doing it? General tree protection, I'm happy to talk about that, because 100 years hence, Madam Speaker, 100 years hence, an anthropologist will take a bird's eye view of this particular moment in history and this particular government and this suite of bills that have been rushed through the House without democratic process or proper consultation or consideration or any respect whatsoever of the constitutional foundation of this nation in Te Tiriti o Waitangi and Hei Whakaputanga. And they will go, that was the point. That was the point when Aotearoa set itself on a path to ecological ruin under the manic ideology of corporate power, anarcho-capitalism, whereby our view of the world is shaped entirely by the idea that private property rights and the accumulation of money is the most important human value there is. You only have to look at some of those ancient books of old that tell you that the accumulation of wealth is not good for anybody. It is not good for the planet, it is not good for people, it is not good for communities, and it's not even good for the people who accumulate the wealth at the end of the day. There is no version of a life on this planet that is not centred around protection of the basis of that life, which is the health of our ecology. The bill before us today is a worsening of what was one of the worst pieces of legislation this government passed, the fast-track legislation. And what is more, as my colleague just pointed out, they've just dropped a stack of amendments on this bill. So we haven't even had half a minute to read through what those amendments are, but we will certainly be debating them over the course of the next few hours. One of the most egregious parts of the fast-track legislation, and this bill makes it worse, is that it takes community out of decision-making. It takes local iwi out of decision-making. It takes the environment out of consideration insofar as it dismisses the upholding of our existing environment laws, and it certainly has no regard for climate change, the existential challenge that threatens us all. And so we made a commitment as the Green Party that we would correct this extreme legislation and the things that it has committed to make happen. The basis of that commitment is a recognition that there is an appropriate place for development, there is an appropriate pathway for people to get a consent and a permission to undertake certain activities, business activities or whatever they are, or farming or whatever you like. But it must be with the consent of the people. It must be consistent with Te Tiriti o Waitangi. It must be consistent with protecting the common good, the health of our rivers, the health of our atmosphere, the health of our oceans, and our biodiversity. Because those are the things that it is the first duty and responsibility of the regulator and the legislator to protect. It is our responsibility as parliamentarians to protect the public good and the commons from those who would exploit it and harm it and destroy it. That's our job, Madam Speaker. This fast-track bill seeks to bypass that responsibility. And one of the more egregious things that it does is it allows projects that have been through a substantive and an extensive process, such as the Taranaki seabed mining project, which has been rejected and resisted by community in iwi and Taranaki for more than a decade, is opposed by even the commercial fishing industry, is opposed by the offshore wind industry, who have been put off the prospects of building offshore wind in Taranaki because of the prospects of seabed mining by Trans-Tasman Resources, bless you. It is a zombie project, Madam Speaker. It has been rejected by all of the courts and tribunals in this land, including the very Supreme Court. The Supreme Court sent it back. It is dead, buried in the ground, and this Luxon government resurrects it through the fast-track process. And it is shameful. It is so disdainful of the inordinate hours and time that communities have spent to say, this is not what we want for our country. Oh, but no, this government's first duty is to some Australian speculator, Trans-Tasman Resources, who want to destroy the seabed off Taranaki for 35 years straight. So we, as Te Pāti Kākariki, wanted to make it clear to industry that this sort of a process by which consents are achieved will not stand under a Green government. We set a line in the sand that stretches from Bream Bay to the sandstone cap of the Denniston Plateau. And that line in the sand is a commitment that any consents issued by this government through the fast-track process for coal mining, hard rock gold mining or seabed mining will be revoked. That is because of how inappropriate this process is. It is a significant act to take and to commit, but that is because this is such an egregious piece of legislation that does not respect biodiversity, does not respect democracy. The message to the mining industry today is that you should not take any heart from this fast-track amendment bill. It does not give you security of tenure. It does not give you a certainty in the future because there is not political support for it across the House. And when there is a change of government, you can be certain this bill will be either entirely thrown out or substantially amended. And what is more, it is a high priority for the Green Party, if we are in coalition negotiations with any other party, that we will stand on what our commitment is, that we will revoke the consents for the destruction of the spectacular 40-million-year-old ecology of the Denniston Plateau for Aussie gold miners. That ain't happening. We will stop Trans-Tasman Resources seabed mining. We will stop the mining of Bream Bay for sand. We will stop the Waihi. You should have a look at the fast-track application, Simon. There's about 7 other sand mining applications. There's plenty of places to get sand without dredging the seafloor.
Back to speaking to the bill, not across the House, in a conversation, please.
Sure. We will revoke the hard rock gold mining in Otago, Bendigo and Macraes and Waihi. Why? Because those forms of mining use cyanide to extract the gold. They leave a toxic legacy of arsenic and cyanide tailings dams that are there intergenerationally. long after any jobs have dried up and the profits have been repatriated to Australia, that legacy is there. The acid mine drainage that we saw in the Hiniwai River down in Coromandel was from a mine 100 years old. Anyone who had worked in that mine was long dead, and probably their grandchildren were dead. This is why this form of extractive, destructive industry is not the future for our country. We need a future based on renewable industries. And we have made a commitment as the Greens, as an alternative to this, just to be clear, that we can create 40,000 jobs plus through renewable industries and backing Central North Island timber processing among other things, but also keeping the mills open that this government is letting close. And they can't afford the energy because you won't reform, I should say they, Madam Speaker, won't reform the electricity market and break up the generator retailers. Get on with it. Fix the problem. Madam Speaker, we will certainly be opposing this bill. This sort of reckless disrespect for people and planet and Te Tiriti has no future. Thank you.
Madam Speaker.
Simon Court.
Thank you, Madam Speaker. Well, wasn't it an eye-opening speech from the Green Party member, Steve Abel, who I do have a lot of respect for his commitment to the environment. I mean, he spent over 240 days in a tree in West Auckland to stop a property development. I'm not sure if those houses have ever been built, so there's probably 240 people who don't have a warm, dry home. But I do respect his commitment to the environment. Even though when he starts to mix up Kiwis' care and appreciation for our natural environment with, oh, and therefore everything must be collectivised, we must nationalise the energy system, and what did he say? That development requires consent of the community. Well, of course communities must have an input into development. The fast-track process allows for views to be gathered, but we can't allow a right of veto to every Tom, Dick, Harry who turns up at a hearing and gives their reckons and vibes as to why something like a housing development or a mine shouldn't go ahead. Now, what does this bill do? It's quite simple. It provides for grocery businesses, supermarkets, to demonstrate that there's a national and regional significance test that they pass so they can use the fast-track system. What else does it do? It establishes a more efficient process for fast-track approvals, which means that instead of applicants having to spend tens of thousands or hundreds of thousands of dollars stacking up technical reports to demonstrate why every risk is managed down to the nth degree, why things you can't even see, touch or feel are managed in a way that the collectivists over there on that side of the House approve of, we are providing a much more efficient pathway. And I want to tell that member, Rawiri Waititi, the story of New Zealand has been people on the other side of the House objecting to development, threatening to nationalise successful businesses that deliver electricity and food to consumers. And that's not going to work for New Zealand. Everywhere that collectivisation and collectivism has been tried, it's led to famine, poverty, the destruction of institutions, the collapse of civil society. You think of Cambodia under Pol Pot. You think of Russia under Stalin. That is what you're advocating, Steve Abel, and that is what you are riding shotgun on, Rawiri Waititi. Now, why is fast-track an important part of the development approvals process? Well, firstly, it recognises that under the Resource Management Act, the Wildlife Act, the Conservation Act, the Public Works Act, that there are approvals needed for many different aspects of a development. And what fast-track does is simply bring them all into one place so that all the evidence can be considered at one place, at one time, by one group of planning commissioners. Now, if you think about viewing the world in a holistic way and
balancing human needs with nature, you'd say actually the fast-track approvals process pulls all these things together in a really coherent way, which is why it's such a struggle to understand as a civil engineer the incoherence and frankly the lack of rationale behind the arguments that we've heard from the left and hard left green wing of politics in New Zealand. I can't understand why someone would bother, like Glenn Bennett, marching down Queen Street to protest against a bit of legislation that makes housing development and getting vital minerals out of the ground easier. I mean, if you honestly think, Steve Abel, you mentioned that there's a whole bunch of other places we could mine sand on land instead of the ocean, would you turn up and write a positive letter saying the Green Party would love you to do more sand mining on land? Like, would you turn up at the hearing and say the Green Party loves land sand mining? Because I don't think you would. I don't think that that's a fair reflection of the Green Party's views. In fact, I think they're 100% anti-mining anywhere ever. And if you really, really believed in that, you'd hand over your cell phones, you'd hand over your laptops, you'd refuse to fly anywhere, you'd be as sound as Greta Thunberg. You'd only come and go from Parliament by boat.
Can I just ask the member not to bring the Speaker into your debate?
Madam Speaker, I do apologise for bringing you into the debate, but I will reflect that Greta Thunberg, even though she's completely wrong about everything, at least has the courage of her convictions to travel to and from the places she wishes to protest and speak at by sailing boat. She's only ever flown on a plane when other people have said, Greta, you get to sit next, Greta Thunberg, you must sit next to the toilets at the back of the plane. And I don't know, maybe that's the kind of sacrifice even the Greens would be prepared to make. But I doubt it, because they don't have the courage of their convictions to say, actually, there should be some mining somewhere, and we will say where it is because we know it's important to New Zealand. Now, this bill is important. We must have a one-stop shop to consider complex development applications. For far too long, the Resource Management Act has made it almost impossible to consent to things we need in a reasonable timeframe and a reasonable cost. It doesn't mean these projects won't proceed. Of course they will. But why would we hold applicants, developers, even the Crown to an impossibly high standard where every single risk must be managed down to the nth degree until you can't see it, or even if you can see it, you know it's there, it's still a risk. That's what the RMA does. Fast Track cuts through this. But what's coming next is going to be even better. We're going to replace the Resource Management Act that has caused all this problem with two new bits of legislation, a Planning Act and a Natural Environment Act, based on property rights in the Planning Act, being able to use your land without having every Tom, Dick and Harry turn up to object to the colour of your front door, and a piece of legislation to establish environmental limits. Now, the opposition doesn't disagree with that. They love environmental limits, and they also love living in houses. So, you know, some of these problems we're trying to deal with the fast track are actually to deal with this legacy, this kind of 1980s cool kids vibe, sustainable management crap that we've had to accept holding us back for over 30 years. Fast track is going to help, but replacing the resource management system with a new system based on property rights is the new game in town. New Zealand's going to have the best planning system in the world. Green parties, I predict, from other countries will come to New Zealand to ask, how did you do it? How did you protect the environment and build homes that people want to live in and have mines? Well, New Zealand's going to show them how. This government's going to show them how. Madam Speaker, ACT is proud to support this amendment to the Fast Track Approvals Act.
Jamie
what?
Thank you, Madam Speaker. I rise on behalf of New Zealand First to support the Fast Track Approvals Amendment Bill in its second reading. And as I did mention in the first reading of this bill, this is a core part of the National New Zealand First Coalition Agreement. And it is, yes, I remember back to that time around those coalition discussions, and this piece of legislation was something New Zealand First had developed and popped onto the table at those coalition agreement talks, and it's a proud moment to actually see this piece of legislation in the House being refined and actually working the way we want it to work. So it's about letting the investment flow, and Mr Speaker, we need to let the investment flow and we need to let the activity flow. There is too much in New Zealand with stopping activity, and this bill will actually get the wheels moving and get the economy moving. As I mentioned, Mr Speaker, it's about fine-tuning. It's about getting the legislation working in the way that we want it to work. And obviously, when the first part of the legislation came through, there has been the need to bring it back to fine-tune it. And one of the great things with the fine-tuning here is we're going to see in the supermarket industry that we're all shouting out for is we want to see more competition. And in the supermarket industry, if we don't get competition, if we don't get new players into the market, we aren't going to see prices come down. We want to see the competition, we want to see new players coming into the country. It's fantastic that the Maori Party's actually agreeing with me. We want to see some competition, we want to see more dollars in everyone's pockets so we can see competition into the supermarket industry. And we're talking, Mr Speaker, of a 6-week reduction. So 6 weeks of red tape cut out. If we can cut out 6 weeks of red tape of having to go through processes that aren't required, will save costs. It will get shovels into the ground and we can get projects underway. And I can't believe that the Labour Party spokesperson is disagreeing with me, but we'll carry on and have a little bit of a discussion about that a little bit later. The other thing about this piece of legislation is it will create jobs now. And we know in the regional New Zealand and across New Zealand, we want to see jobs being created. We want people to be in jobs. And by getting activity and a pipeline of work, and again the Labour people just can't agree that we actually want to see people in real work. And we actually want to see people out and actually developing these supermarkets and getting shovels in the ground, and that is going to create jobs and activity across New Zealand. A big thing with this piece of legislation, Mr Speaker, is the pipeline. The government has said that we want to create a pipeline of infrastructure work that when one job finishes, you go to another job. So if we can get a pipeline of infrastructure work in the country, across the country, contractors can have confidence to go from one job to another job. So, and again, we're hearing from the opposition about employment. If we can get that pipeline, we can actually get people into work and working across the country. We want to promote a strong infrastructure development pipeline that promotes productivity. So if we actually can get these projects up and underway, we will see more work come from it. We can see contractors having the confidence to invest, and then we can have more confidence in businesses to invest more and to actually want to actually develop more work throughout New Zealand. What I can't understand, and we're hearing it through the opposition as I'm speaking today, is the no to everything. I got up earlier on today and was talking about consenting, and it's anti people that actually want to do things in this country. And on this side of the House, we actually want to see people invest, we want to see people have confidence, and we are actually backing the people that will get New Zealand moving. We don't want to hear a no attitude to everything. I've just heard from Mr Abel, he said he's saying no to housing developments, saying no to mining, they're saying no to supermarkets, they're saying no to energy projects, they said no to fast track. They can't say no to everything. We actually need to have productivity, we actually need to have businesses working, and we need to actually have the ability to actually employ people. And if we're going to keep having a no attitude and be so negative, the economy is not going to turn around. This side of the House, this government will turn the economy around. We'll have a pipeline of work that will lead into the future, and people will have the ability to invest, and they will have confidence. And on that, Mr Speaker, it is with great pleasure that I commend this bill to the House.
5 minute split call, Rarere Waititi.
Thank you, Mr Speaker. I find it difficult to listen to some of the speakers in this House today. And we saw with the last speaker, he banged his mic. He thought this was going to be his mic drop moment of a speech in this House. And the only anti in this House is a government that is anti-te tiriti o Waitangi, that is anti the environment, that is anti-workers' rights. And all I have to say to Jamie Arbuckle through this speech is buckle up. Madam Speaker, what we have in this fast-track amendment bill is the public have spoken. 95% of submissions opposed this amendment bill. Every opposing submitter raised the same alarm, that the bill sidelines the tiriti o Waitangi and hands unprecedented power to ministers, Tom, Dick and Harry. The government are not fast-tracking progress, they are fast-tracking cronyism. The core issues, and what this government is obsessed with removing te tiriti o Waitangi, is the red flag. The bill replaces the tiriti partnerships with ministerial discretion. It is vehemently opposed to te tiriti. And we have seen that across many bills that have passed through this House. And now under urgency, you are urgently moving bills in this House that removes the fundamental constitutional agreement that protects Aotearoa, from corporate exploitation. And this is what this bill does. It reduces Māori to optional consultees, deepening Crown dominance, meaning ministers can approve or decline projects without recognising iwi, hapu, or honouring te tiriti o Waitangi. This reverses decades of legal precedents, including MACA Act, EEZ Act, RMA, and the 2021 Supreme Court on the Trans-Tasman Resource Seabed Mining decision. Iwi feedback and all iwi submitters oppose the fast-track amendment bill. Ngāti Ruanui, Ngā Ruahine, Ngāti Toa, Waikato Tainui, Buupoko, Ngāti Kuku, Ngāti Whakau e ki Maketu, Te Runanga o Tākau, Ngāti Rangi, Ngāti Hauahapu, Patu Harakeke Te Iwi Trust, Ngā Rauru, Ngāti Maru, Ngāti Tahu, Taranaki Iwi, Te Atiawa, Te Nehe Nehe Nui, Ngāti Manawa, Ngāti Rārua, Ngāti Kuia, Te Tōpuni and Ngā Rahu Trust. The government cannot erase Māori from the law just because we are inconvenient to your investors. This is what this bill does. It sidelines Māori from decisions about whenua and moana, reopens extractive industries already rejected by courts and by iwi. It ignores tikanga, customary rights and treaty settlements. Loss of Māori voice and participation. The bill restricts who can submit, it limits hearings rights, it compresses timeframes, reduces opportunities for appeal. Hapu and whānau directly affected are locked out of decisions where Māori once exercised kaitiakitanga. This bill silences them. The process now privileges corporate applicants over communities, defending taiao and heritage. Māori Ward Council warned Manawatu has 10 hapu still unsettled and lacking treaty settlement protections. Te whānau Apunui are the same. Te Tai Tokerau are the same. The bill leaves them exposed to decisions made without consent or involvement. What we have, Madam Speaker, is a constitutional overreach that concentrates power in ministers, removes Māori from decision-making, dismantles tiriti protections, sacrifices whenua and moana for short-term corporate gain. We stand firmly with iwi hapu whānau communities across Aotearoa opposing this bill, and will repeal this bill and entrench te tiriti. This is not fast track, it is a fast trick. A trick that hands power to ministers and corporations while stripping power from Māori communities. The government can silence us in this legislation, but they cannot silence us in this House or across Aotearoa. Thank you, Mr. Speaker.
Lan Farm.
Thank you, Mr. Speaker. I wonder what kind of new misery this is. Because we have been in this situation in Aotearoa, New Zealand, for decades of governance where some duty of care was owed to the environment. And again, we are reaching new levels of dismissal. And I want to make it really clear that the original fast track approvals bill was already completely unacceptable in its overreach. It was already completely undermining communities' democratic participation. It was overriding the Crown's very clear obligations to iwi and hapu under Te Tiriti, and it's weakening environmental laws and protections. That's already unacceptable. But now, if that wasn't enough for this government that want to push things out so far that these processes that we've been accustomed to in this country that have some form of legitimacy and legal standing no longer apply with this. This has pushed it out so far, it gives more weight and more strength to our very clear position as Te Pāti Kakariki that we will revoke consents when it comes to coal mining, seabed mining and gold mining in particular, because of how egregious it is that they sidestep these environmental protections. And I want to also touch on some comments that we heard earlier from the ACT member about a lack of an argument from the hard left for being against this bill. And I want to start with a submitter that we heard in the Select Committee process that is not from the hard left. They're an independent fast-track panel convener who is independent of the Environmental Protection Authority, who actually appoints experts to these panels. And what they said was they warned the committee to, quote, be alert for unintended policy outcomes and to proceed with caution here. Quote, impractical, unworkable changes will simply concentrate pressure on panels. Were this to happen, the quality of some decisions will be very vulnerable to appeal and judicial review. Now, why that is so critical that this government actually listened to those conveners is because they hold up the integrity of the very process that these decisions are made under. And what they said that this bill does is it threatens the reputation of these independent panel members that sit on these panels to make these decisions. This is how extreme this bill is. And unfortunately, from the little we've been able to make of the short time we've had to look at this amendment paper, it doesn't look like the government's listened. Nope. So what that means is that this process is going to be somewhat, if not completely illegitimate, when it comes to these decisions having to stand up to appeals, having to stand up in the courts. And I think that should be of serious concern to this government, and yet they're not listening. So be it. Let's push this through today like they're going to. Any government that pushes through a bill that departs so significantly and irresponsibly from these long-held democratic legal safeguards and threatens political influence in independent decision-making under urgency needs to be challenged, it needs to be called out, and 95% of New Zealanders who submitted on this bill called it out. They said, we do not want this bill, and surprise, surprise, it's going through because the applicants, past and present, have gotten in the minister's ears. It's completely unacceptable and we oppose it.
Catherine Webb.
Really sad to hear on that side of the House the culture of no, 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 slow, slow, slow. When on this side of the House we are wanting development. We're wanting the housing developments, the renewable energy that we so desperately need, powering up our growers and our farmers so that we can strengthen this economy and create jobs and opportunities. And look, when it comes to supermarkets, we need to create more supermarket competition so that we can reduce the cost of living for hard-working New Zealanders out there. And this is what this bill is all about. Look, I would just like to take this opportunity as chair of the Select Committee to just thank our members for the fast process that we took with this bill to obviously get it through to its second reading here today, because it is about getting more competition into our supermarket sector, and we know that we need to get things built faster in this country. We need to get the consenting regime and our planning regime a lot more streamlined and effective. And this is what this bill is about, as well as obviously making some technical changes to the fast-track process just to make it more effective and more streamlined. And it was actually very good to hear from the fast-track panel during the Select Committee process, whereby they said it was running very smoothly, it was going well, and they did actually mention some of those great projects that have already been passed, which of course is the Port of Auckland, Bledisloe North Wharf, and the Ferguson Berth extension, as well as the Maitahi Village development in Nelson, and of course the Milldale development. So these are all positive, and we want to see more of these fast-track projects are being approved. And of course, during the process, we heard from the Port of Tauranga. And this bill, of course, will ensure that we can get that stellar passage and that wharf at Tauranga built and constructed. And why is this important? Well, this is important because at the moment, the Port of Tauranga is turning away ships, turning away our New Zealand exports, our kiwi fruit, our apples and our red meat, when actually we can be welcoming those ships and getting that produce off to market, getting the value for the New Zealand economy and strengthening our economy. So it was good to hear the reality of the situation that we're in with the Port of Tauranga. I visited them actually recently, and I could see the potential from our largest port, which obviously needs to get a wharf built, expand that wharf, and obviously welcome the ships in so that we can get more exports and grow our economy. We also heard from the Tukituki Water Storage Scheme, which of course is very, very important for my own region of Hawke's Bay, where we're actually seeing 37-degree days at the moment in Hawke's Bay. It is so hot. We've got drought on the back door, we've got drier summers, and we don't have water storage. Yet we are one of the most productive regions in the country. And so the Tukituki Water Storage Scheme is very, very important to growing our economy in Hawke's Bay, but actually growing what we already have there, and of course supporting many jobs and opportunities in the region. And so of course that project is on the fast track at the moment, and so this, of course, will be very important for Hawke's Bay because it's going to unleash economic potential in our region. It's going to diverse the land use that we have at the moment across the Heratonga Plains, across the Ruataniwha Plains. This is a very, very important project, and with climate change on our door, with droughts on our door and drier summers, we need water storage. So that is very important. And of course, during the process, we also heard from the energy companies, and it was very interesting to hear from the energy companies because they said one of the most restrictive barriers to bringing renewable energy online at the moment is the consenting process, because they cannot get it online fast enough. And look, I'll give an example. Recently I was up at Te Pahui with my wonderful colleague, Napier MP Katie Nimmin. Welcome back to the House, Katie. It's great to have you back. Look, and we were up there opening this wind farm. It took 20 years to get this wind farm constructed. It was 2 years to build it. So this balance is absolutely out of whack. We need to bring renewable energy on a lot faster and more efficiently. And this is what Fast Track is all about. It's about getting renewable energy projects built faster and more efficiently. And look, the last element that I just want to talk about was the retirement villages, actually, who we heard about through the select committee process, because of course we've got an ageing population and we are wanting to encourage more development in our retirement village sector. And they said that one of the biggest barriers to getting retirement villages built in New Zealand was the consenting process. And of course, when you see large investment like this, you need certainty when we're going to get that capital investment into the country and we're going to get these retirement villages built, which of course is very important to addressing our ageing population. And so having Fast Track provides the fast lane to getting these projects built, and they are so important for strengthening our economy, creating jobs and opportunities across New Zealand. So I commend this bill to the House.
The Honourable Priyanka Radhakrishnan.
Thank you, Mr. Speaker. It is so incredibly frustrating sitting here and listening to speeches from members on the government benches who wax lyrical about how their government wants to strengthen the economy, create more jobs, they'll build a whole bunch of things. But the reality, Mr. Speaker, is that they've built absolutely nothing. And because of their decisions, 20,000 jobs in the construction sector alone have been lost in New Zealand. So it is incredibly frustrating to listen to members who talk about wanting to build things, wanting to support the construction industry, when everything that they've done goes against even that. They also talk about the need for a faster consenting process, Mr. Speaker. No one's denying that. No one's denying that we need to build things better and faster, that we need a strong economy. What is frustrating is the idea presented by members on the government benches that the economy and the environment are in opposition, because that is a false dichotomy. We absolutely need a healthy environment if we're going to build a sustainable and strong economy. And that is the point that members opposite seem to fail to understand, because the chair of the Environment Select Committee stands up and talks about development, not once mentioning how this bill will absolutely ruin and put in decline the environmental protections that we need in this country. The original Fast Track Approvals Bill was described as an assault on the environment and on environmental protections. That was absolutely correct. 20,000 people marched down Queen Street in opposition to that bill because they felt that it was ministerial overreach. It was a government that would dictate what happens when it comes to development at the detriment of the environment. And so then this government made a couple of changes. Okay, so 3 ministers would no longer be able to veto the decisions of the panel that they themselves put in place, but instead the panel would have the ultimate decision. And then now what happens, Mr. Speaker? They have a piece of legislation that they claim will be all about increasing supermarket competition, but it's not. Because there are about 100 other changes in this piece of legislation that they describe as technical, small changes, rats and mice, nothing to see here, because it's all about supermarket competition, Mr. Speaker. If that were the case, we would be supporting this bill. But it's not the case, is it? This bill is a Trojan horse. It pretends to be about supermarket competition. The word supermarket is mentioned, what, once, maybe twice? Groceries is mentioned once, maybe twice in this bill. But what does this bill actually do? And I'm going to quote the Parliamentary Commissioner for the Environment here, Simon Upton, because I think he puts it very clearly when he says that the effect of the bill will almost certainly undermine the legitimacy of the fast-track process, the robustness of its decisions, because it seeks to make the approval of applications almost inevitable by providing the Minister with a mechanism to insert tailor-made government policy statements to which weight must be given by the panels. And I want to touch on that. We have laid it out very clearly in the Labour Party differing view in the Select Committee report. It is a shame that the chair of the Select Committee didn't bother to mention this point that was raised by so many submitters in the very short period of time, given the unilateral decision by the chair to shorten the submission process. Parliament did not have the opportunity to debate that as we usually would. Labour members on the Select Committee put up a bit of a fight, well, quite the fight, over the process because it is so undemocratic, and yet, unfortunately, the Environment Select Committee chose to go with the chair's unilateral decision. Despite that, Mr. Speaker, there were a number of submissions on this very point. The bill introduces a new type of document that is relevant for decision makers, and it is the undefined government policy statement, or the GPS. Now, this GPS is discretionary. There is absolutely no criteria that is laid out for what the government policy statement should entail. There is no specified process for the development of the GPS. There is just the requirement for the minister to come up with this GPS. It can be whatever the minister decides to put in it and as wide as the minister wants to go. And the only requirement is to consult with other ministers and then to publish it. So this means that the GPS could be really anything. And if that had been confined to supermarket competition, as this government claims the bill is about, then we would have had no problems with supporting that. Because on this side of the House, we do want to see progress. We do want to see development. We want to see a strong economy as well, but not at the expense of a healthy environment as well. And we struck that balance with our fast-track bill. But unfortunately, we've got a government who doesn't care about the environment, runs roughshod over it, brings in a bill that was egregious, that tens of thousands of people marched on the streets against. They changed it in response, and now they want to change it back by stealth, because that's what this bill does. It goes towards concentrating power in the hands of the minister through this GPS. It severely limits the participation of third parties. We've heard that through a number of submissions from environmental NGOs, from conservation groups who submitted to the Environment Select Committee process. And many of them pointed out what also the PCE, the Parliamentary Commissioner for the Environment, has said. It speeds up the process that already makes, he says, that already makes heroic claims on the ability of parties to assemble material to the point that proper scrutiny cannot be reliably undertaken. And I want to point at this juncture, Mr. Speaker, to a couple of projects that have initially applied through the fast-track approvals process. Things like the open cast mine on Denniston Plateau. The Denniston Plateau is a unique ecosystem in New Zealand. It's a hotbed of plant biodiversity and bird life as well. there is a project for open-cast mining on the Denniston Plateau. The Tukuha coal mine out on Westport, Mr. Speaker, rejected by the Environment Court in 2020, brought back, taken to Supreme Court, rejected by the Supreme Court in 2023, reapplied under the fast-track approvals process, and it was returned by the panel because it raised serious concerns there. So the panel, the fast-track panel, and its ability to be able to invite commentary by the likes of conservation groups like Forest and Bird adds rigour to the process, Mr. Speaker, and that is the process that this government seeks to undermine through this bill, which is ostensibly about supermarket competition. And it's not. It restricts the discretion to invite comment. It brings in a whole number of steps that need... So for a government that seems to hate regulation, when it's convenient to them and they want to bring in red tape to slow down the processes of the fast-track panel and the rigour with which the panel can operate, it does that. No problems. We'll bring in a whole bunch of extra steps there and we'll reduce their ability to make robust decisions. The panel convener submitted on this, Mr. Speaker, on this very point. We heard that the timeframes are too short. It was interesting, even the applicants of fast-track projects, many of them who submitted to the Select Committee made this point, that the required timeframes that are now reduced within this piece of legislation is too short. So it's egregious from the point of environmental protections. It's not particularly good enough even from the point of applicants. It's a pretty bad piece of lawmaking that this government is bringing in. The final point that I want to make is the fact that Shane Jones has waxed lyrical and has been very public in his criticism of the Environmental Protections Authority, the EPA. He's called for the fresh limitations on appeal rights and the ability of the government to give a general direction to the EPA as particular importance in this piece of legislation. And that's what this bill does. It inserts a new section that allows the Minister to give general direction to the EPA in relation to its performance and its exercise of its functions, duties and powers under the Act. We are concerned that this administrative role of the EPA is not being respected and that the Minister could very well interfere in the decision-making process. And so, Mr. Speaker, I end where I began. 20,000 people marched on Queen Street because of the ministerial overreach in the original bill. That was changed and it is now being brought back through stealth, through this very bill that the government claims is about supermarket competition and is absolutely not. And for that reason, Mr. Speaker, we don't commend this bill to the House.
Grant McCallum.
Thank you, Mr. Speaker. Well, earlier this year, our Prime Minister, in the State of the Nation speech, talked about the culture of no that was encompassing this country. It did develop. It's what we had become known for. In fact, I'll give you an example of how that culture of no has made it international. Recently, the CEO of the Ports of Auckland, Roger Gray, was overseas in a cruise ship at a cruise industry conference, and he said, "Why will you not come to New Zealand?" He's asking the cruise liners, people, owners and so forth. They said, "Well, actually, we don't call you New Zealand, we call you No Zealand." That was the quote. That is an absolute disgrace. It's a sad reflection of where we have got to as a country, right? It's about, well, clearly the opposition are not interested in tourism. They don't want tourism. They don't want tourists. They don't want things happening. Listen to them. You know, they're quite happy to live in this bubble that exists in a special place that no one else wants to live. So, and a lot of nonsense coming from the other side as normal. But so, look, and so that was a really sad story, Now, about supermarkets, it's interesting, you know. They say, oh, yeah, we support the supermarkets, we'd support that bit. Well, really, it's interesting. When we were in the Select Committee, the Mayor of the Far North, Moku Tupania, he was speaking, and I asked him the question, is this important for the Far North, the improvement of the reduction of restrictions for opening a supermarket? He said, absolutely. You know why? It was about grocery prices and it was about the town of Kaitaia. It was about the town of Kaitaia he highlighted, where there is one supermarket, and the council up there, the Far North District Council, is very, very keen to see some competition, so that the people of the Far North get the opportunity to choose and have better grocery prices. A really, really important thing. Now, look, there's something I'd really like to address in my call, and that is the disgraceful stand of the Greens in terms of wanting to cancel consents. Absolute disgrace. So they're saying to people who come and invest in this country, they build and they create jobs, we're just going to take that consent away and stop it, and just stop it. That is a disgrace. It's a sad reflection on the Green Party. The Green Party of Rod Donald would never have done that. The Green Party of the people gone past would never have done that. That is a disgrace, because we as a country need to be responsible players in the global sector if we are to be taken seriously and attract the investment to create jobs. So the Greens, you are a disgrace and a sad reflection on parties before. I commend this bill.
5-minute split call, Kushla Tangeri Manuel.
Tēnā koe e te māngai o te whare. My, how the mood has changed since the emergency management bill. Hoi anō rā, tēnei te miha te kia koe kei tēnau mai hoki mai. Aotearoa kia Matara. We received 2,518 written submissions on this in the small window of 10 days, and 95% of you opposed this bill. And this government don't care. They don't care about your voice, and they are taking us backwards. If they're going to give you 10 days to consult on this, imagine what they're going to do when the bulldozers come into your town. Will you be there? Will you know about it? Perhaps, because you will be notified. Mr. Speaker, this is one of the bills that sends shivers down the spines of constituents throughout Ikaroa Rāwhiti, and especially the East Coast. When considering this, my mind went back to the early 2000s when the East Cape rose and activated against seabed mining, drilling. That's going to happen again, but it shouldn't have to if, in fact, this government takes heed and actually takes the collaborative approach they are espousing to take. One of the main issues here is kaitiakitanga. One of the members opposite has said, oh, they're talking about things we can't see, touch and feel. Ko hekurangi te maunga, ko waiapu te awa, ko Ngāti Parau te iwi, no rangitukia awau. Those are all things we can see, touch and feel. But what you can't see, touch and feel is the connection as kaitiaki. That, in fact, is invisible. And that's why this is so important, because we get one go at this. Our whenua, our awa and our moana have to endure forever. Whonga uri whakaheke. There's been a lot of talk about property rights, Mr. Speaker, and I'm sure everyone understands here that most general land can be bought, sold, developed at will. But whenua Māori and ture whenua Māori is often multiply owned, has all sorts of different interests according to whakapapa. Now these are not going to be, these are going to be voluntarily considered under this bill. Don't just take my word for it. I took the opportunity to read some of the submissions from Ikaroa Rāwhiti and the submission of Te Hungaroia Māori o Aotearoa, who absolutely support the whakaaro of my colleagues on this side of the House. Te Hungaroia Māori warn that this bill materially reduces the practical ability of Māori to exercise rangatiratanga. While we know that doesn't matter to this government, the exercising of rangatiratanga, that's why they're trying to delete it from every legislation in this country. It diminishes Te Tiriti Partnership, it curtails natural justice, and it permits executive overreach. I'm having a bit of an internal giggle because there's someone on that side trying to say my speech. But furthermore, local and regional councils have concerns about this. Greater Wellington Regional Council stated in their submission that this will erode the ability of iwi and hapu, like Te Awa Kairangi, Te Whanganui-a-Tara, which for those of you who don't know is where we are, Te Awarua o Porirua, Wairarapa Moana and Kapiti Coast wetlands. The Upper Hutt City Council is deeply troubled by the removal of meaningful consultation. They state, quote, meaningful consultation is replaced with, quote, notice in writing and only 20 working days notification. That's despicable. So, Mr. Speaker, I know that one of the claimed intentions, is that this will bring all the voices together. Iwi, councils, hapu, landowners. But in fact, as my colleague Priyanka Radhakrishnan said, this is actually a Trojan horse. This is trickery in disguise. The genuine intention will not be honoured. We can move forward in a collaborative way, Mr. Speaker, if every voice is counted as genuine and people are not treated as Tom, Dick and Harry. When 95% of submitters make a statement, surely that is valid to be listened to, Mr. Speaker. We do not commend this bill to the House.
Katie Nimon.
Good to be back. And look, I appreciate all the acknowledgement, especially from my East Coast colleagues. We're all lined up here and in good order. Look, I just want to talk about supermarkets. We've talked about them a little bit. I think that it's actually really important to make this point. And we love a good pun, right? While in this particular bill, supermarkets can't take themselves through self-checkout, they can go through the express lane. And I just need to take you back to Hawke's Bay and the farcical situation that we've had in Hawke's Bay that does not help one single person get a more affordable grocery basket. Now, you want to build a new supermarket in Hawke's Bay. Do you think that you could do it in the middle of Napier? No, because Countdown have 2 Countdowns across the road from each other. In fact, right by my office, and it's actually a real tourist attraction. You can't build a new supermarket anywhere else in the area because, of course, all the plans disallow it. And there's another little story in Catherine's electorate, no less, where my family used to have a bus company, got sold to a supermarket. They couldn't get consent to build a supermarket. And so, of course, because they didn't want to sell the land to another supermarket because, heaven forbid, they could get the consent. There might be some competition. So they divided it up into 4 different titles so that nobody could ever build a supermarket. They had to do some different trades around and potentially trade the land with someone else so that they could build a supermarket where there was consent to be able to operate a supermarket. Oh my goodness, the lengths we go to build a supermarket to bring in competition. Now, I don't think that it's going to work if the same people just expand and, build a bigger supermarket. We need new people. We need to be able to build something new where we don't already have it. Do you think that we could do that any faster than we build wind farms, as my colleague Catherine Wedd mentioned earlier? No. We can't expect the existing operators to decide between themselves that they're going to make groceries more affordable. We need new people to come in. Yes, we're getting a second bigger Costco. Do you know how long that took them? It's absolutely unreasonable. So this bill is a very, very necessary amendment. We need to add things to the fast-track bill. We see it working. And when it's working, we need to expand it to make sure that every single competitor that needs to be in this market is able to operate. So if we can make sure that the consent is available, we can fast-track it by up to 6 weeks in some cases to get the very necessary building to happen. We've just opened IKEA. You can go and get meatballs in Auckland. Furniture that was far less affordable. We're talking about the grocery prices. But this goes far beyond that, and my colleagues have talked about it as well. It's a very, very important amendment to make. I think members opposite are far dramatising some of the very, very practical decisions that are being made here and bring on the RMA reform that has been introduced, and it is going to make a massive big difference to our economic recovery, to our economic growth, growing the pie in New Zealand, because that is what this is all about. We are absolutely supportive of economic growth, and that is what we are here to do. Make no mistake, I commend this bill to the House.
Glenn Bennett.
Speaker, and it's interesting to listen to what has been said across the House this morning, and the previous speaker talking about her 2 Woolworths in in Napier, and lovely, wonderful. But the thing is, where are supermarkets mentioned in this bill? If I look through, not once do I see supermarkets actually mentioned in the bill, not once. Yes, groceries, oh yes, they were mentioned one time, once, just once. And that was the only time that groceries was mentioned in this bill. So as we look at some of the rhetoric that's come out this morning, we've got to look at what it actually is, Mr. Speaker. And I think this is a fast track to yet again undermining our environment. It's a fast track to yet again undermining democracy. We look at the process we went through, and it was a challenging process, Mr. Speaker. And so therefore we cannot support this bill. In fact, we need to stand up and we need to oppose it. Mr. Speaker, we do not commend this bill to the House.
Ryan Hamilton.
Thank you, Mr. Speaker. It's great to speak to this amendment bill and the fast-track amendment. Mr. Speaker, there was some resistance to the fast-track amendment bill when we brought it in, and we actually got to hear from the EPA during the Select Committee process. And I think it was the CEO, Mr. Speaker, said that she had some reservations, she had some concerns. And in fact, the Parliamentary Commissioner for the Environment, do you remember that, Rachel Brooking? You were there. The Parliamentary Commissioner for the Environment, Simon Upton, he said he also had some concerns, but he was actually pleasantly surprised by the way the process has been going. And I think we've had 5 approvals so far, but quite a few more in the pipeline yet to come, which is really a good indication, Mr. Speaker, that it's actually working quite well. And I guess the intention of this bill was to, to enhance those aspects where it wasn't working so well, to streamline some of that process. And that's really the intent of this bill, Mr. Speaker. But also, of course, the supermarket aspect of it as well was really important. And there's been a little bit of talk from the opposition that we haven't talked much about supermarkets, but it's actually a really integral part of it. And the former Speaker, Katie, actually just mentioned Costco and IKEA, which, we've been talking about New Zealand for a long time. And Mr. Speaker, those things are really important for not only the economic benefit of New Zealand in terms of the employment they bring, but of course also the wider impact they bring to the competition sector and offering a cheaper deal for New Zealanders. And so we're really excited about that. And in fact, recently, Mr. Speaker, I had the privilege of going on a parliamentary trip to Canada, and I got to go with some of my colleagues, David McLeod, and in fact Tracy McLennan from Labour as well, and a Green Party member, Huhana Linden. And Mr. Speaker, the reason why I tell that story related to this particular amendment bill is we sat down in Manitoba and talked to some of the First Nations chiefs, because as you'd appreciate, Mr. Speaker, they have challenges similar to us or parallel to us with their First Nations people, and for us obviously Māori iwi, and they were very interested in our treaty settlements, and particularly with this fast-track bill and how the implications play out legally, and of course the intricacies of treaty settlements and te tiriti, which the Green Party member spoke about earlier, as did Rawiri Waititi. And Mr. Speaker, David McLeod asked them how long it takes them to consent a project in Canada. And of course, the First Nations chief said, well, it depends on the project. Obviously, there's different complexity and nuance with every project that we come across. But David said, as an example, just a general, big project to consent, and the First Nations chief said about 2 years. And Mr. Speaker, that was quite an eye-opener for us, because our fast track would be doing well if we approve things within 2 years, Mr. Speaker. But that was an example of just how slow we take to do things. And Catherine Wedd, we have got safeguards too, Ingrid Leary. That's right. But our chair was referring earlier, Mr. Speaker, to a wind farm in Hawke's Bay, which took about 2 years or 3 years to build, but 20 years to consent, Mr. Speaker. And it's just not sustainable anymore for us to do that. And that's why we're making some big changes. And of course, the macro changes around RMA are key to that and key to this in terms of streamlining the process. But this amendment paper specifically is around improving that fast-track process. We have looked at truncating some of the turnaround time for the, for submitters when they approach, make a consent. We tried to maybe fast-track the fast-track, and there was a bit of pushback from the EPA, from the Parliamentary Commissioner and some submitters, and I believe that the Minister is considering an amendment in the Committee of the Whole where we will actually adjust that. So we had some comments from the opposition that we weren't listening, but Mr Speaker, the Minister is listening. That select process, although it was quite quick, it still enabled a good, and efficient. Mr Speaker, we had submitters present to us here in Wellington, and of course during the recess week we also held Zoom meetings and heard from some other submitters as well, which was really important. Just on the supermarket, one of the, the precedents we've seen, for example, many of you will know about Halswell in Christchurch. Did I say that right, Vanessa? Halswell. In Christchurch, Mr Speaker, where Woolworths took 4 years to get a resource consent, and so they effectively said it's a multi-year, multi-million-dollar barrier. And of course those costs, when we're talking about the price of butter, the price of cheese, those costs to set up the infrastructure to house the very thing that we're trying to increase competition has to be passed on. And so that $4 million of resource consenting, you can imagine how many percentile increments on 500 grams of butter that's going to be passed out. And so again, that's a really good example. And another example is the Wairau in Pak'nSave that took nearly, some commentators say it took nearly 2 decades to consent, because the resource consent actually got declined twice, Mr Speaker. Such was the process. And that was a really quite a drawn-out example, Mr Speaker. But what this tells us is that New Zealand is just not attractive for these big supermarket players. In fact, there was another one in Rolleston, Levi Road, Selwyn, Pak'nSave, where the rezoning and the resource consents just took too long. Consent was eventually granted, but the project needed to proceed to construction, but only after very lengthy consenting, plan change interaction and with the council. In fact, there was another one, Mr Speaker, Pioneer Countdown in Palmerston North. Timeline again, it was a proposed $16 million new supermarket, but the application was refused by independent commissioners for failing to meet urban design integration risks. That's right, Mr Speaker, a supermarket in Palmerston North, not necessarily known for its urban design, potentially. I don't want to speak out of, I don't think there's any MPs from Palmerston North here, Mr Speaker, but failing to meet because of urban design and integration rules. The consent was refused. What about Central Intago, Mr Speaker? Anyone here from Alexandra? Proposed countdown in 2020. The planner recommended a decline of a new countdown because of adverse effects. Urban, traffic and amenity. Again, amenity. This is a supermarket that's not designed to look particularly sexy, Mr Speaker. They're designed to sell baked beans, butter, milk and bread, and it was declined. The outcome recommendation against consent. Hamilton's got some new supermarkets, but actually thank you for mentioning Hamilton, Mr Speaker, if you will indulge me, it is the city of the future. It is the fastest growing city. We have got international flights, but we have got a Pak'nSave being built, but the council made them significant traffic management, which Pak'nSave had to pay for, which is fair enough from the ratepayer perspective, but it's so much cost that the Pak'nSave has to incur, and that cost is going to be passed on. So, Rachel Brooking, when you come through on the 110 Expressway from Auckland, listening to cruise control, if you want to stop into that Pak'nSave, the price of butter just went up, unfortunately, because they need to pass on that cost. And so this is really the intent. Yes, that's what I'm saying, Rachel Brooking. Because if the capital cost is reduced, because the resource consent is more streamlined and easier, they don't have to pay for what, sorry? It's going to be much more, okay, it's going to be much more streamlined. So it will be much more streamlined, and therefore that cost saving and cost efficiency will be able to pass on to the voter. Mr. Speaker, I commend the bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakahe.
Action New Zealand. New Zealand First.
In favour.
Te Pāti Māori.
E whā ngā poti whakahe.
Tāku Te Whereas.
Kotahi te poti whakahe.
Marae Mino Kapakingi.
Kotahi ngā poti, te poti whakahe.
The ayes are 68, the noes are 55. The question is agreed.
Fast Track Approvals Amendment Bill, second reading.
This bill is set down for committee stage immediately. I declare the House in committee at the conclusion of question time. So the House will now break for lunch and we will be in committee at the end of question time.